This is Justice, History, and the Law. Lectures, discussions, and interviews from the Robert H. Jackson Center in Jamestown, New York.
July 23, 2003. Professor John Q. Barrett spoke on Justice Robert H. Jackson on Security, Liberty, and Law at the Chautauqua Institution Amphitheater during Security and Justice Week. How Robert Jackson balanced protection of the individual while securing the nation against foreign aggression during the period leading up to World War II was the subject of Professor John Barrett's discussion at the amphitheater during the third day of Justice and Security Week at Chautauqua Institution. John Barrett is a professor of law at St. John's University School of Law, New York. Professor Barrett edited That Man, the late Supreme Court Justice Robert Jackson's previously unknown memoir of FDR and the New Deal. Barrett's interest in Robert Jackson stems from his words and the opinions he wrote as a Supreme Court justice.
Thank you very much, Joe and Chautauqua Institution and the Hagen Fund and you Chautauquans for the opportunity to speak from this hallowed platform. This opportunity and privilege is particularly special for me because I will be speaking today about two men, a bit about President Franklin D. Roosevelt and quite a bit about his colleague and Attorney General and Supreme Court appointee Robert H. Jackson, who each themselves spoke from this platform, of course some years ago, to packed houses about the very same topics that we are all considering this morning and throughout this week, devoted to justice and security. My topic is Robert H. Jackson on security, liberty, and law. This is, as Joe said, a history topic, but as with any good history topic, it is a topic of contemporary importance. History is relevant to what we are and where we are, and particularly in this area of justice and security. What I'll be considering is four parts on this topic. First, a background on who Robert Jackson was. Second, what Jackson stood for on the issues of constitutional liberty and the place of courts versus other governmental actors in providing the protection for our constitutional liberties. Third, what Robert Jackson stood for on the rule of law, particularly as exemplified by his own extensive career in the executive branch, not as a Supreme Court justice, but his career in the executive branch. And finally, having worked our way through Jackson, Jackson on liberty, Jackson in the executive branch, I will conclude with some thoughts and material on Jackson on us, that is, citizens and the leaders we select to work for us, to represent us, to be with us in complicated times. So first, Robert H. Jackson. In one life, a short life also, a 62-year life, 1892 to 1954, Robert H. Jackson is the path and the history of this country. Think, at least for comparison, of Abraham Lincoln, 80 years later. For Jackson, born in 1892, is that same upward trajectory from very humble farm beginnings and self-taught development and early career in the law and then public service to the hopeful future of this country. Unlike Lincoln, however, Jackson's trajectory does not conclude in the 19th century, but concludes in our time. For the world of the 1940s and 50s, the mature environment of Jackson's life is in many ways the world of today. The technology, the issues, the structures, the government that he dealt with during his mature years are the same that we grapple with today. Now, where did it start? It started in a little place called Spring Creek, Pennsylvania, actually due south of here, about 30 miles, just below the state line, where Jackson was born on a family farm in 1892. As a young boy, he moved a little bit east and a little bit north across the state line to Frewsburg, New York, a lovely little town, but if you blink, you'll miss it, where he went to public school and had a traditional late 19th century, early 20th century boyhood. He was a product of rural schooling in small classrooms, multi-grade configurations for some of his educational background. He was very involved in the basic education that he got and the extracurriculars of debating and speaking and elocution. His family was, turn of the 20th century, comfortable but not extremely prosperous. His father worked in a variety of ventures, first a farmer, then a hotel operator, then the keeper of a livery stable, and always someone who bought and traded horses, a topic on which young Robert Jackson learned one of his best early lessons from his father. They rode the rails to Pittsburgh in a boxcar full of horses, and young Bob, about age 9, watched his father wheel and deal and trade away the horses they'd brought with them and get horses to take back to Frewsburg. And he pulled his father aside and said, "You didn't even look at the horses you just got in the trade." And his father told him, "Sometimes all you need to know is what you're trading away." A life of practical wisdom. The Jackson family was literate, but not in a sophisticated sense. There were books in the home, but not a vast library. The key book of his childhood was the King James Bible, something that he repaired to regularly, quoted, used, and emulated in his own writing. A key part of his childhood was the natural world, as you'd imagine in a small town in the rolling countryside of southern New York, northern Pennsylvania. He had a pony from the age at which he would no longer fall off, and for his whole life was a horseman and loved to ride and be in the woods and fish and climb and hunt and hike. It was an independent childhood of exploration, of nature, of space and freedom and individuality. And those are things, of course, that become directly relevant to his work in our public governmental processes and in the constitutional heritage that came to be his work. He graduated from Frewsburg High School at the age of 17 and spent the next year, the year 1909-1910, as a postgraduate student at Jamestown High School. At Jamestown in that year, he gained a couple of special teachers who were key mentors and shaping influences in his life, exposing him to sophisticated literature, to Shakespeare, start to finish, a couple of times through, reading plays late into the evening at the teacher's own home, after hours, to history, including a lot of British history, including some German history, to writing, to speaking, and among other things, to the Chautauqua Institution, where he, by horseback and by rail, would travel up the lakefront and attend lectures and programs and absorb some of the richness that even in those days were part of the environment, as they so obviously are here now. By age 18, all of this gave young Robert H. Jackson an interest in the law. The mentor who really is responsible for that is a cousin on his mother's side who was a lawyer and an active Democrat in Chautauqua County politics and a very strong influence because he was a very strong personality. He was somebody Jackson's father disliked, and based on that, I think not wanting his son to grow up to be a protege and much like this gentleman, Jackson's father refused to pay for any legal study. So he went forward on his own. Freedom, individuality, independence. In those days, you needed 3 years of study before you could sit for the bar, and you had to be 21 years of age. And so after that postgraduate year at Jamestown High School, Jackson, at age 18, worked for a year as an apprentice in the law office of this cousin up his mother's side of the family tree. After 1 year as an apprentice, he went to Albany, a place where this gentleman had taken him regularly because of his political involvements. And Jackson spent that year at Albany Law School, taking 2 years of classes in 1 calendar year. But he was still only 20 by the time that year was over, and Albany Law School declined to give him a degree because he wasn't yet 21. It gave him a certificate of completion, but not a degree. Somewhat embarrassed by this fact, they gave him the degree a few decades later when he was Attorney General of the United States, and further made amends by giving him an honorary doctorate 10 years later when he was a Justice of the Supreme Court. For educational administrators, let that be a lesson. And so at age 20, having completed that 1 year of law schooling, Jackson returned to Jamestown and spent his 3rd legal preparatory year again as an apprentice, again in the law office of his mother's cousin. By that point, he was riding and traveling around the countryside trying cases in justice court. Justice court was something like we could have right here, right now, if you have a beef with something he did to you. It's citizen-level justice wherever somebody is acceptable to both and sits down to be an adjudicator. And you would have a representative, and you would have a representative, and sometimes a trained, busy lawyer wouldn't be available, but a kid would do it for the experience, and that was Bob Jackson. So he actually, in an unauthorized practice of law sense, I must say, tried hundreds of cases before he took and passed the bar and became a lawyer the following year. And that was it for formal education. No college whatsoever was a part of this man's background. Only 1 year of law school, but an independent, sophisticated path of training in the real world. And so from age 21 until age 42, Robert Jackson rose to become the leading lawyer in this region and one of the leading young lawyers in this state and somebody who was beginning to make a mark in national legal circles. He was a courtroom litigator of great talent. Those oratory and debating skills became part of what he worked magically in the courtrooms locally and regionally. He also was involved in all other aspects of law, including corporate representation, sometimes for municipalities, sometimes for private clients. Really sort of a polymath lawyer. And also, you remember that cousin was a Democratic politico, he was rising as a Chautauqua County Democrat. Never running for office himself other than a party office, which turned out to be more of a pain than it was worth when he was a young man, but always involved in campaigning, in speaking on behalf of candidates, in strategizing. And one of the relationships that comes out of that Albany law, New York State Democratic politics confluence of aspects of his life is a friendship, first an acquaintance, then a better acquaintance, then a friendship with a young New York State senator from Dutchess County, New York, Frank Roosevelt, who also, much like Robert Jackson, was something of a nobody at the time. He did have a heck of a surname, but other than that coincidence, a lot of people thought the FD stood for feather duster. But the Democrats took a chance on him, and he got elected and served in the state Senate, and then went to Washington and served as Assistant Secretary of the Navy. Then, obviously, after being slaughtered as the Democratic Party's vice presidential nominee in 1920, contracted polio and disappeared from the political scene for about 5 years. But Jackson had the friendship and the relationship and maintained the contact, and when Roosevelt came back, running and winning the gubernatorial position here in the state of New York in 1928, one of the campaigners and brain trusters involved, and then increasingly involved during his two-year terms as governor, was young Robert Jackson. In 1934, a year after Roosevelt, Jackson goes to Washington. He is a true New Dealer, not in the initial Brains Trust group, which was the campaign, Moley, Tugwell, and so forth for students of the period, but their successor group, which is the Corcoran, Cohen, Jackson, Ickes generation, the brains and the people who were at the heart of the New Deal, literally sitting on the foot of the president's bed at night and early in the morning, drafting speeches, working on policy, debating issues, going out to lead the charge. And in a 7-year period, Robert H. Jackson has a meteoric rise, I think like no other that I know of, in the executive branch of the United States government. Buckle up and watch this one. His first position in 1934 is General Counsel of the Bureau of Revenue in the Treasury Department, today's IRS. It was an administrative job, a staff of 200 lawyers. It was tax law, which was not particularly his specialty. It quickly bored him out of his mind, and he found a way to reconfigure it into a position that his deputy could handle, freeing him up to be part of this White House Brains Trust, freeing him up to take on a very significant national case. That's 1934. Within 2 years, he's an assistant attorney general, heading first the tax division and then the next year the antitrust division. In 1938, he becomes the Solicitor General of the United States. In Justice Brandeis's phrase, he was such a good Solicitor General, he should be Solicitor General for life. Arguing and representing the constitutional position of the Roosevelt administration before the Supreme Court and really winning the constitutionality of the New Deal during that 1938, 1939, 1940 period. In 1940, Jackson ascends to the top job in the Department of Justice, Attorney General of the United States, where he serves for 18 months and describes the work as a department of war through law, because the issues he's dealing with are entirely national security in focus. Obviously, the workaday business of the Department of Justice, law enforcement is there, but the priority is the coming World War, which the President and the cabinet that now includes Jackson realizes will inevitably embroil the United States. In the summer of 1941, Roosevelt appoints Jackson to the Supreme Court, and that becomes a later phase of his career. In each of these executive branch positions, Jackson wields enormous responsibility and has enormous impact, and I think is enormously shaped by what he does. The major case I referred to at the Treasury Department was the prosecution of Andrew Mellon, the former Secretary of the Treasury under Presidents Harding and Coolidge, briefly Hoover, and then our ambassador to the Court of St. James for the rest of the Hoover administration. This is, in other words, the Roosevelt administration prosecuting the Treasury Secretary in the administration that Roosevelt had defeated in 1932. Now, you talk about a politically charged case. Whatever is our most recent case of the century, this was that case. And Jackson, who Roosevelt knew as a great lawyer, and who Jackson knew was bored out of his mind supervising 200 tax lawyers, personally volunteers and is selected and is sent to Pittsburgh to try the civil case after the criminal phase had been botched. And Jackson prosecutes this case brilliantly, very controversial, very aggressive opponent, Frank Hogan, who was a premier criminal defense lawyer and civil defense lawyer in his day, to national headlines. It makes Robert Jackson's mark as the lawyer for the biggest case, a thought that Franklin Roosevelt files away and uses later. At the Department of Justice, Jackson aggressively, as an Assistant Attorney General and as Solicitor General, is a defender of the political branches of government, by which I mean the legislature and the executive branches, the branches that are elected and democratically accountable, as opposed to the judiciary, which of course is not elected or democratically accountable, at least not directly. And Jackson becomes, in 1937, the most effective, because he was the most candid, proponent of FDR's court packing plan, something that we generally in popular memory remember as some radical, crazy idea that thankfully was defeated. I must tell you, it was a conservative idea. It was a democratic idea. It was a rollback of a Supreme Court that had aggrandized itself with its power to interpret the Constitution and used the opportunity to implement its economic theories, notwithstanding elections and legislation and the signing of bills pursuant to very broad grants of power, such as the national power to regulate commerce among and between the states. Now, the politics didn't work because Roosevelt spun it out with disingenuous explanations at the beginning, and those weren't Jackson's explanations. Jackson cut through that and testified and almost saved the court packing proposal, which I think is an open question historically about whether we would be better off if that had happened. He also, as I mentioned, wins the constitutionality of the New Deal, the Social Security Act, the National Labor Relations Act, the Securities and Exchange Act, major antitrust laws like the Public Utility Holding Company Act, all of which were anathema to the ideology of the 9 old men who had been the old court, are upheld by the new court on the advocacy of Robert Jackson. And as Attorney General for those pivotal 18 months, January 1940 until June of 1941, Jackson is the President's principal legal advisor on all issues relating to the coming World War, and the chief domestic law enforcement officer in a time of domestic insecurity, complicated investigations, and challenges to civil liberties. Of course, it's a formally accurate fact that we had no Secretary of Homeland Security until Tom Ridge assumed that newly created office in our recent memory. And of course, it's a fact that we never had until 2001 domestic experience with an act of terrorism like 9/11 or an enemy group like Al-Qaeda. But it is too easy to say that our era and the war and these challenges are all new. Because in fact, during this 40-41 period, our nation was filled with fears of terrorism, of sabotage, of disloyalty, and with a greater certainty than we have today that bloody conflagration was imminent. From Hitler's invasion of Poland in September of 1939, through his alliance with Soviet Russia, through his alliance with the fascists in Italy, in a United States filled with people of Italian heritage, like myself, people of German heritage, like myself, communists. The Attorney General was at the point position in dealing with these issues of domestic homeland security. That's the background. Now let's move to the area where we primarily remember Robert Jackson, at least as a Supreme Court justice, and this is due to the beauty of his writing. We remember him as, in key moments, a liberal judge and an eloquent defender of civil liberties. And indeed, that is one of the things that he stood for at his core: protecting the individual against the state, preserving space against government intrusions that would interfere with the individual's right to define and live his life. I think that goes back to the life of rural autonomy in New York near the turn of the 20th century that shaped him. His vision of the Bill of Rights and constitutional liberty was a guarantee embodied in the document for each of us to get an opportunity to have what he had: a place to chart a path, to form beliefs, to develop associations, to express views, to pursue livelihood, to live life. Where does this manifest itself? Most famously, it manifested itself in a case called West Virginia Board of Education versus Barnett. This is a case that some of you will remember as a case involving the flag salute, which the state of West Virginia had compelled in all public educational institutions. The flag salute involved an unfortunate gesture and the Pledge of Allegiance. And in the time of coming World War, the flag salute was obviously a well-intended demonstration of shared patriotism and commitment to the ideals of Americanism. It was challenged by Jehovah's Witnesses in the state of West Virginia, as it had been challenged unsuccessfully just 3 years earlier by Jehovah's Witnesses in the state of Pennsylvania. The difference between those two cases, the 1940 case and the 1943 case, is in part the passage of time and further reflection on what it meant to uphold compulsion to do this, even imposed on people whose religion tells them that literally the command of Exodus, that thou shalt have before thee no graven images, makes it a sin to pledge allegiance to the United States in this fashion. Partly it's the reflection, partly it's the passage of time, partly it's the commencement of the actual war by 1943, and I think centrally it's some of the new appointees to the Supreme Court, including Jackson. Jackson writes the majority opinion in this Barnett case that reverses the earlier opinion and strikes down this flag salute. And I'll read you just a couple of paragraphs that sang then and sing now, and I think are at the core of this civil liberties aspect of Jackson. There is no mysticism, he wrote, in the American concept of the state or of the nature or origin of its authority. We set up government by consent of the governed, and the Bill of Rights denies those in power any legal opportunity to coerce that consent. Authority here is to be controlled by public opinion, not public opinion by authority. The case is made difficult not because the principles of its decision are obscure, but because the flag involved is our own. Nevertheless, we apply the limitations of the Constitution with no fear that freedom to be intellectually and spiritually diverse, or even contrary, will disintegrate the social organization. To believe that patriotism will not flourish if patriotic ceremonies are voluntary and spontaneous instead of a compulsory routine is to make an unflattering estimate of the appeal of our institutions to free minds. Interestingly, the governor of Pennsylvania last year signed legislation that compelled every elementary and secondary school in the state of Pennsylvania to begin the day with either the national anthem or the Pledge of Allegiance. It created an option for people to opt out of that ritual, but provided that any student that did so would trigger a notification to his or her parents. That was challenged in court, and just last week was struck down as having missed the point of Barnett, decided on Flag Day 1943, and still at the core of what freedom under our First Amendment means. And Judge Kelly in Philadelphia wrote an opinion that at length quotes from this Jackson opinion. Other areas where Jackson's judging stood for civil liberties include the Korematsu case, which invalidated the relocation order aspect of the Japanese-American internment system that went into place in early 1942. It upheld it. Jackson was one of 3 dissenters in that case, and his opinion, which I will return to, declares what should be, and I think today is the obvious reality, that we don't make criminal procedure based on race, and we do not assign guilt based on ancestry. In that time, only 3 of the 9 justices, however, found that to be a self-evident constitutional reality. Jackson was one of them. A third place is Brown versus Board of Education, decided at the end of Justice Jackson's last full term on the Supreme Court. He's one of the 9 justices who unanimously invalidate the system of segregated elementary and secondary education in the claim that separate can be equal. But beyond liberties, Jackson stood for the rule of law. And indeed, the point I'd like to emphasize is that he viewed the rule of law as a defining component of liberty. As a lawyer, he was devoted, of course, to the craft of law and believed in formal, careful, deliberative, open process. But what he added in his writing and his judging in this pre-war or intra-war phase and also after World War II was a series of explicit statements about the necessity for society, government, and order as a precondition for liberty. In other words, for all the libertarian fervor of a Barnett or a Korematsu or a Brown versus Board of Education, liberty can't be limitless. Liberty isn't free. And liberty that destroys the system, the constitutional prerequisite for liberty, is obviously a contradiction in terms. It was on this issue that Jackson's judging separated him from some of the others who you may remember as the great liberals of his court and his time. I think Jackson's view was the more sophisticated, grounded view of liberty. Where does that leave the courts in this matter of liberty? Jackson obviously became a judge, and the court was his professional destination. But I think it's interesting that he viewed courts as not the primary venue. Remember, that's what the court packing fight was about. Courts aren't running us, we're running us. And the Constitution sets up a system in Articles 1 and 2 that creates democratically responsible branches before it gets to Article 3, which allows the democratic branches to create a judiciary. Contrast this with 2 views. This is from Alberto Gonzales, President Bush's White House counsel, probably our next Supreme Court justice, if and when a vacancy occurs. Gonzales said this spring, "We do believe very strongly in the protection of civil liberties, but there is a competing interest to the protection of national security." Okay, so far. "The key for the government is to try and find the appropriate balance." Okay, so far. "We think we find that. But ultimately, quite frankly, it's going to be up to the courts to tell us if we've made the right decision." Absolutely not, said Robert Jackson. Courts may and will be heard on aspects of this at points in time when matters are justiciable and it travels to a definitive resolution. But in the meantime, and in the vast span of government conduct that affects liberty, courts will not tell us if we're behaving within our constitutional framework or if we've lost sight of who and where we are. It's the other branches. Other end of the spectrum. This is an ACLU fundraising letter from Anthony Romero, the executive director, which says the judiciary is the first line of defense for individuals who believe their civil liberties have been violated. Absolutely not, would say Jackson. Jackson knew this, I think, as a matter of constitutional understanding, history, textual analysis, and also experience, because in the executive branch, he had been part of this accountable, responsible exercise of constitutional power. Now, by executive branch, I mean the functions that are allocated to the president in Article 2 of the Constitution, and they include law enforcement, they include prosecuting, they obviously include the range of cabinet responsibilities. And Jackson, serving as Solicitor General and Attorney General, is nearly as high as one can get, particularly in those times, in the exercise of executive power. And of course, his vantage point was an extremely close one on the actions, the behavior, the leadership of perhaps the most powerful, decisive, interesting, and important chief executive that we've ever had, but certainly in the 20th century, Franklin Delano Roosevelt. And these are some of the measures that were Roosevelt administration executive actions with obvious liberty implications that Jackson was part of deliberating, drafting, creating, considering, and defending. After the invasion of Poland, FDR in September 1939 declared a limited national emergency, which was an articulation of his powers to goose and accelerate the national defense production system, an armament gear up, basically, because it was coming for us and we would need to produce much more. And through that process, there was not much legislation or appropriation. There was just an announcement for the president that we are going to begin this greatly accelerated production. In the summer of 1940, Jackson is the intellectual father and legal defender of the deal by which Roosevelt and Churchill agreed to swap 50 American destroyers for basing rights in British colonies in the Caribbean and North Atlantic, Newfoundland, Bermuda, etc., places where the Navy now has a permanent presence or a long-term presence, comes out of this deal. We gave them 50 boats out of our naval arsenal. That's a disposition of property that on some reading of neutrality laws and other legislation, Roosevelt was not able to do. That's a desire, and it's an important geopolitical move, but it needs a legal explication, analysis, and defense. And what Jackson did during that summer of 1940 was figure out and present the argument. And on that basis, Roosevelt goes forward, which obviously had tremendous consequences for the British Isles surviving in that immediate period. He also, as supervisor of the FBI, which the Attorney General is, although the FBI doesn't admit that very often, approved preparations to, on the start of war, arrest identified persons of German and Italian heritage who were in the United States, based on FBI analysis of activities showing disloyalty. These are leaders of the German-American Bund and other such organizations. But on the commencement of war, Hoover's plan, with Jackson's approval, is to arrest and prosecute those people. The alien registration statute that's passed in the summer of 1940 to get a documented handle on the immigrant population in this country is legislation that's drafted and defended by Jackson. The August 1940 return of selective service. Talk about something that runs into your liberty as a young man, that's high on the list, is a Jackson legal project, and then a Roosevelt piece of legislation and a reality. Roosevelt's May 1941 declaration of an unlimited national emergency, not the limited declaration of the fall of 1939, this is now unlimited. And as a statement by a president, there's never been a broader one, or frankly a more frightening one if carried to its extreme, of power to do whatever needs to be done, is drafted, tweaked, somewhat restricted, and shaped by Robert Jackson. But the next month, his last month as Attorney General, Roosevelt's deployment of U.S. Army troops to take over an aircraft production facility in California that had been halted by labor unrest is a seizure of private property, legally justified by Robert H. Jackson. I give you these not to indict him or to criticize him, but to show you that there is a visible path of very serious executive activity that is part of this man's background before he ever goes on the Supreme Court. Did he have sensitivity in doing this? Well, Jackson gave one of the most famous speeches in the Department of Justice history, something that's quoted and replayed constantly for prosecutors about the ethical way to do one's job. Because part of what he did when he became Attorney General was rein in and clean up a mess that his predecessor had allowed to develop in the area of prosecution. These are some of Jackson's words in that speech about how to prosecute. In times of fear or hysteria, political, racial, religious, social, and economic groups, often from the best of motives, cry for scalps of individuals or groups because they do not like their views. Particularly do we need to be dispassionate and courageous in those cases which deal with so-called subversive activities. They are dangerous to civil liberty because the prosecutor has no definite standard to determine what constitutes a subversive activity, such as we have for murder or larceny. Thus, we should concentrate our prosecution on actual acts rather than associations or beliefs or ethnicities. And he did that in running the prosecution aspect of the department. He also was a pain in the side of J. Edgar Hoover. I can't tell you the trail of memos up to Jackson and back down to Hoover and then around Jackson from Hoover to the White House saying, wiretapping, have to do it. Jackson's putting a restraint on us. Arresting more aliens, have to do it. A general internment system, have to prepare to do it. I'm not talking about Germans and Italians, not people of Japanese descent. And in each of those, the roadblock, which is ultimately a dialectic process that gets resolved at a higher level, is Robert H. Jackson. He sets up a special unit for civil liberties, which drives Hoover. May he rest in peace, and I apologize. Drives Hoover bananas because it creates a supervisory level on top of the FBI in its investigations of people of foreign heritage. And Jackson even reaches outside the government. There's one moment that I think captures this. He goes to New York to debate the chairman of the Republican National Committee at the Town Hall of the Air, which was, sort of every Sunday morning show plus everything else you could think of as public discourse. He was doing that because Roosevelt was playing coy, and if Roosevelt had not sought the third term, one of the likely Democratic nominees in that period would have been Robert H. Jackson in 1940. So Attorney General Jackson goes to New York to debate the chairman of the Republican National Committee, and he absolutely cleans his clock. His name is Mr. Denny, and it's a tape that's a marvel to hear. But that's a digression, because the afternoon before the debate that evening is used by Jackson to walk downtown to meet in a hotel coffee shop with Mr. Grenville Clark, who was a private lawyer in New York and a liberal Democrat and very involved in civil liberties issues, including the ACLU National Board, and very concerned about Gestapo-like tactics and excesses by the Department of Justice, including particularly with regard to people of alien heritage in this country. The Attorney General, no security detail, no formal meeting, no hoopla, goes to sit down with this man for 2 hours in a coffee shop to hear his concerns, to articulate his own vision, to consider the implications of the power he exercises back in the government. And the end of that process is a Jackson proposal to Grenville Clark that Clark assemble persons such as himself to be an advisory committee that Jackson can draw on and ultimately move to Washington to be part of helping him supervise and think about Hoover and the FBI and the commencements of these cases and these measures. Maybe discretion and classified information today keeps us from knowing about such activities, but my small bet would be that Attorney General Ashcroft has not been in such a coffee shop with such a lawyer. And I think we are poorer for the lack of input and the tunnel vision that may demonstrate. Now, Nuremberg, jumping ahead a few years, is executive activity. And I'll only speak to this briefly because I anticipate some Nuremberg-related questions from you. But FDR, in late 1943, publicly pledged to hold the senior Nazi leaders legally accountable after the war. At that point, we knew we would win. Much hard fighting and casualties still ahead, but we knew we would win. And this is post-war accountability. And FDR's vision, which I think it's not an exaggeration to say is really a vision for who will prosecute Hitler, is Robert H. Jackson. After all, he'd handled Andrew Mellon just fine. And so beginning in that time period, Jackson begins to prepare and study and develop his own thinking about what such a task would entail. And what Jackson fastens on and begins to articulate in his writings and his speeches as a Supreme Court justice before the war has ended is a vision of a real trial, not obviously summary executions, and also not a quickie trial, but a real trial, which means all the attachments of American due process, a burden of proof on a prosecutor, an independent and resourced defense on behalf of each defendant, an independent judiciary not in league with the prosecution, a public proceeding, the compilation of a record, and to get to the bottom line, the real possibility of acquittal should an individual not be demonstrated to be guilty beyond a reasonable doubt of particular charged crimes. And then, of course, Roosevelt was gone, and Truman executed the plan and appointed Jackson, and that is what he did at Nuremberg in 1945, 1946. That is an exercise of executive power, but I think with a libertarian constitutional grounding, even though it's occurring abroad. Where does this role model leave us with regard to citizenry and leaders? I think Jackson, in his life, in his writing, in his executive conduct, is telling us not to expect courts to save us from ourselves. They may come along in moments and provide the clarity, the answer, even leadership, which is what Jackson admitted and viewed and participated in Brown versus Board of Education. But in general, we're on our own in our representation and in ourselves. Sometimes, obviously, a clear case of executive excess can be checked. President Truman's seizure of the steel mills in 1952 is such an example, and Jackson's part of the majority that strikes that down. But more often, it's realistic to expect the check, if there will be a check, to come from elsewhere. Where? Well, first, from executive leadership exercising self-restraint. There is a portion of Jackson's Korematsu dissenting opinion with regard to that aspect of the internment system that is often commented upon and viewed as somewhat nihilistic, because he says, after he says this is unconstitutional and we shouldn't degrade the Constitution by saying it is constitutional, Jackson says this probably isn't a case we should take at all. We shouldn't be deciding this because the military is going to do what the military is going to do. And that's a sobering realization. But think about how many divisions and weaponry the Supreme Court commands versus General DeWitt and the military governorship of California during World War II. If the Supreme Court had said no internment camps and DeWitt had said, make me stop, we obviously would continue to have internment camps. Jackson wrote, I would not lead people to rely on this court for a review that seems wholly delusive. The military reasonableness of these orders can only be determined by military superiors. If the people ever let command of the war powers fall into irresponsible and unscrupulous hands, the courts wield no powers equal to its restraint. The chief restraint upon those who command the physical forces of the country, in the future as in the past, must be their own sense of responsibility to the political judgments of their contemporaries and to the moral judgment of history. Now he's talking to General DeWitt, and he's talking to President Roosevelt in saying, restrain yourself and don't expect us to stop you from your excesses. I think that is an important lesson. Jackson also looked, however, beyond leadership to the citizenry, to a citizenry that knows it has responsibility, that remembers its heritage with regard to responsibility, that teaches itself, and of course the younger among us, that self-government is the system that we have created in our constitutional order. It's captured in a beautiful line from a speech that Jackson gave near the end of his life to the American Bar Association annual meeting in Boston in 1953. He said, there is no such thing as an achieved liberty. Like electricity, there can be no substantial storage, and it must be generated as it is enjoyed or the lights go out. We need to live as if we are fully the people that our Constitution declares we are, is part of the message that Jackson is saying. It is no accident that Jackson, at the same time he was giving this speech, was writing about Franklin Roosevelt in the manuscript that Joe mentioned, which is the book that actually premieres here this week at Chautauqua, a place that Jackson and Roosevelt both love so dearly. Because more than any judicial opinion, I think, telling and reflecting on the story of Roosevelt, including the exercise of power and the greatness, the moments of excess, the moments of brilliance and restraint, in that embodiment of a president, is one of the most important lessons he left us. But it is also not just a backward-looking historical kind of thing. You remember the phrase was, for the past and also for the future. Robert Jackson had a core quality that I'll close on. Despite all he had seen and experienced in his life, and that late 30s through mid-50s phase of his life is a time of war, different types of war, but total war. He also at Nuremberg, of course, saw and proved the reality of the Holocaust. This is a man who had seen a lot and lived through a lot that could leave one jaded, negative, bitter. He'd worked at Nuremberg with Soviet communists. He probably saw the Cold War begin in some of his meetings at Nuremberg with the Russian prosecutors and in the conduct of the Soviet judges. He came back from all of that with optimism, and he expressed that in two places that I'll close with. One is right here at this podium, where he spoke on the 4th of July, 1947. I'm sure it's not literally this podium. I'd love it to be. But I have to tell you, an aura does surround this place. And he said in that speech to this audience, to these people, his home, after Nuremberg, after all he'd seen and proven and experienced in the war and the toll, that war wasn't inevitable, that human interaction and systems such as law left him hopeful, even in that moment where we're descending into a Cold War and worrying about the final war, a World War III of a nuclear aspect with the Soviet Union. Jackson said no, because we have ourselves and what we stand for and the ability to work as we've always worked for our betterment. He also said it in a speech a little bit north of here in Buffalo in that same final period of his life. This is his optimism, and I close with this. It is customary to tell students, he was speaking at the University of Buffalo, how urgently these great issues challenge them and how they will soon have to face the greatest challenges of history. I forbear such extravagances. The problem of liberty and authority ahead are slight in comparison with those of the 1770s or the 1860s. We shall blunder and dispute and decide and overrule our own decisions. And the common sense of the American people will preserve us from the extremes which would destroy our heritage. He believed that, and I believe that, and we embody that. When we remember who we are, as his life demonstrates a person can remember who we are, we're fine. Thank you.
Thank you, John. The ushers will be around to take your questions in writing. Please make them short and legible. Mine is sort of a personal one that's occurred to me for quite some time, and that is, how did Jackson, who came from this area, rather conservative background, you explained his uncle and his early education and influence there, but how did he reconcile his personal and social life with this liberal, progressive way of life? I mean, the people he hung out with here in Jamestown were people like my dad, who were about as conservative as they'd ever come, and who said, that man, and I don't think I ever heard the name Roosevelt in our house, but these were his buddies, and how did that work?
I think it's the triumph of attractive personal qualities and decency over the political labels that would otherwise divide people. Jackson was, as he wrote, the son of a Democrat who was the son of a stiff Democrat who paid someone to fight for him in the Civil War, and who took pride in having voted against Abraham Lincoln twice. And that was the heritage of affiliation that Jackson was born with and stuck with his whole life. I think obviously the substance beneath the label changed, and in many ways Abraham Lincoln came to be a great hero of Robert H. Jackson. And Franklin D. Roosevelt came to be somebody who Jackson viewed as much like Abraham Lincoln. But you're right about the climate and the sort of Republican world he grew up in. There's a quip that somebody told a Jamestown reporter, and it's in a newspaper, reporting on a dinner that was held in Jackson's honor in May of 1940. This is the period where maybe he's going to become president, so we better throw a big dinner in his honor. And so Jamestown turns out 5,000 people, his friends and clients, and 98% of them rock-ribbed Republicans who are going to vote against Roosevelt if he's running. We'll see what they would do if Jackson was running. And somebody tells the Jamestown newspaper, Bob Jackson is just the greatest guy in the world. I don't know what's with his politics, but I love the guy. And I think what that reveals is that politics and labels are too easy a place to stop your assessment of a person. And when you get to know somebody, the substance is there, and you transcend whatever boundary might have been in the label.
You started down this road and mentioning Lincoln. Who were Jackson's role models in the executive or judicial branch?
Well, F.D. Roosevelt is certainly a major shaping influence. At earlier points in time, Jackson has a couple of interesting people he fastens onto. One is Charles Evans Hughes, former governor of New York, Republican, former Republican presidential nominee who barely lost the 1916 election to Woodrow Wilson. And Jackson was a Wilson Democrat and a Chautauqua Wilson Club president and so forth. But when he got to Washington and began to deal with Hughes, and Hughes was by that point Chief Justice of the United States, it actually became a personal relationship, and Jackson, I think, learned that his own labels were probably a little bit too conclusory, because he saw in Hughes a kind of centrist greatness and ability in application. So those are two, Hughes and Roosevelt. I think he was also quite close to some of his colleagues in the Roosevelt cabinet, and in certain aspects, he was one of the younger, so I think in certain aspects he learned a great deal from one of the Republicans who Roosevelt brought in 1940, and that was Henry Stimson, the Secretary of War. So those are sort of three large shaping influences.
I'm going to put you in Jackson's shoes for a while and ask you how you think Jackson would have ruled or thought in some recent cases or some important cases. What would be his, this is more generic, but what would be his take on the extreme politicization of the judicial confirmation process that we see now?
I think he would lament it with a smirk, because we assess this as extremely politicized. We forget what we've been through in so many areas, and this is one. Robert Jackson was a bitterly contested, controversial nominee when Roosevelt appointed him Solicitor General in 1938. Those hearings and that Senate debate is a knives-out, bloodletting exercise that rivals anything we've seen in recent times. Obviously, the scale is a little bit different, but Bork or some of the federal appellate nominees who are currently very controversial. Jackson for Solicitor General was that kind of thing. What's going on is pure politics. He's Roosevelt's guy. He's being nominated for this very powerful position at a time when Roosevelt has lost some standing with the public, and at a time when the political enemies of Roosevelt are obviously starting to look past Roosevelt, expecting 2 terms will be the end for him as it had been for every previous president. And this is their chance to smite young Jackson right here and now. And it's fascinating reading, and dozens of senators vote against him, but he wins. Jackson had no problem mixing it up with people on the merits. And as long as that's what a bitterly contested process is about, it's a process that he was in up to his neck. When it gets personal or substance-less, then I think it's not very Jackson-like, and he would lament that to the extent that that's happening.
What do you think his opinion would have been in the 2000 Supreme Court case on the Florida voting?
Well, I'm always reluctant to play Ouija board. with regard to Justice Jackson, in part because each generation confronts new issues. The constitutional issues of the time he is Solicitor General are national legislation and economic power. The constitutional issues in the 40s become war and liberty issues. The constitutional issues in the 50s become Cold War issues. In the 60s, they become criminal procedure and social change and egalitarian issues. And, obviously, he never decided a presidential election case. But I think it's one easy place to guess that his reflex would have been, don't ask the court to solve this one for you. It might have been very messy, but the Constitution does have a process for contested electors being accepted or not in the House of Representatives. And it would have, I think, been a function of Republican majorities in Florida appointing their electors, who would have been Bush electors, and then the lame duck Congress, which had a Democratic majority, would have fought and battled it. And probably in the end, the Bush hand was stronger than the Gore hand, if that path had been taken. A mess, but in the end, we would have a president, one guy or the other. And Jackson would not have leaped to be part of the court that took that question away from the political branches.
The Jackson Center is a historical and educational facility dedicated to preserving the legacy of this country lawyer who became Solicitor General, Attorney General, a Justice of the Supreme Court, and served as chief prosecutor at the Nuremberg trials of Nazi war criminals following World War II. To learn more about this program, Robert Jackson, the Jackson Center, and upcoming events, the Jackson Center is located at 305 East 4th Street, Jamestown, New York, and found on the web at www.roberthjackson.org or contacted by telephoning 716-483-6646.